Good afternoon, everyone. We're going to go ahead and get started. My name is Mark Henriquez. I am co-chair of Womble Bond Dickinson's COVID-19 task force. We're going to be talking to you today about something that I think is on the mind of a lot of our clients and friends. I was excited to look over the long registration list and see so many of the firm clients and associates and other friends of the firm attending today. And I'm glad you decided to spend Friday with us. We've been done a number of webinars looking at issues from COVID-19. It's now been almost 6 weeks since our first webinar looking at preliminary conditions just as the shutdowns were beginning to occur. A lot has happened in that intervening time. We are now in a new month. It's May 1st. And I think a lot of people are thinking about that next stage. What happens next? How do we reopen? How do we begin to move back to some sense of normalcy, which I think many of us are longing for, and it may take a while to get there. We're excited to talk to you today about general liability considerations. This is actually the first in a series of webinars that Womble's going to be doing over the next week and a half, talking about a number of issues surrounding return to work. And I'm excited to talk to you about those today. Again, I'm in our Charlotte office. I also have Sarah Tucker, a partner of mine in our Atlanta office, and Greg Horton, a partner in Charleston. Sarah and Greg, thanks so much for joining us today.
Thank you, Mark.
Happy to be here. Happy Friday.
Yeah, no, I think we're excited, and we're going to spend some time talking. Again, this is going to focus on some of those liability considerations. As trial lawyers, we know what to be worried about from a lawsuit perspective if things go that way. I did want to start, though, with an overview of some of the other topics we're going to be covering in separate webinars. So we've got one coming up next week on May 5th dealing with employee privacy and company data. We have one then on the 6th on return to work. That's going to really be focused on some of the environmental safety considerations. So what do you need to do in terms of cleanliness, in terms of preparing that workspace, organizing it away, looking at some of the OSHA guidance that has come out on that topic. I do encourage you to do that. My partner, Brad DeVore, will be heading that up. On May 13th, we're going to be talking specifically about employment considerations. My partner, Richard Rainey, will be talking about some of the issues that are on a lot of people's minds about people returning, coming off furlough, and those issues. On May 7th, we're looking at doing one on insurance considerations, particularly thinking about what are the considerations with applying for insurance coverage, particularly things like business interruption coverage, reviewing some of the litigation that's going on right now on those in those areas. And we've got a bunch of recorded webinars on the site already. There's one on supply chain disruptions that a lot of people have been interested in that we posted March 30th. I think there's 6 or 7 others. There's some on the PPP. If you haven't applied yet, there is some new funding for that, and it hasn't run out quite yet as far as we know. So if you're interested in the Paycheck Protection Program, there's a lot of information on our website. And you can get alerts and invites if you go to womblebonddickinson.com and go to that COVID-19 hub. It'll be the first thing you see when you log on to the site. If you put your email address in there, we will email you alerts as we issue new advisories. We've got one coming out this morning on the PPP, in particular, some new guidance about making sure that you've made the proper certifications and the right to take advantage of that safe harbor provision by returning funds by May 7th. So look for that. And if you sign up, you'll get all our alerts, as well as notification about these upcoming webinars and an opportunity to sign in. So we encourage you to go there. Let's pause. I think everyone's excited about reopening, but reopening is still a ways away for a number of people. And so I wanted to talk a little bit about what we are seeing across the nation. And one thing that our firm developed is a dedicated website. It's actually stateclosures.com. You can see an image from that website here on the screen. I've been fascinated to see this state, the United States, change colors as we go. So gray means there has been no shelter in place order. And when we first started, the map was almost all gray. I think we had California and New York, maybe 1 or 2 other states were the first ones to go yellow. And we're like, oh my God, they're sheltering in place. Things are shutting down. And over the course of the last 6 weeks, the country has moved largely yellow. There are a few states that you still see there in gray that never implemented formal shelter in place. But now we're seeing states begin to turn green, which means that at some level they are reopening. And what you can do, if you go to stateclosures.com, you can hover over the state and click on it and actually see the statewide orders in place. I do need to caution you that there are also, in many cases, local ordinances at the county or city level in many jurisdictions that may be different than the statewide restrictions. So you will need to check and see what local restrictions may be in effect. We can only track them at the state level. And the reopenings are often complicated. So we've started doing some blogging on those. If you have specific questions about one of the states, we can probably get you more information as well. But it's been an interesting target in a moving process. And, you know, I think it's difficult to give clear national trends. What I would say is some states like California still are closed indefinitely. They don't have a reopen date. Other states have set reopen dates that are fairly far out. Virginia comes to mind. It's got a June 10th reopening date, which is still, you know, more than a month away. But other states are shorter. And I thought, since I'm in North Carolina, and we've got Greg with us from South Carolina and Sarah from Georgia, we give a little more detail on those states. I'll start with North Carolina and then turn it over to Greg. In North Carolina, they've decided to do a phased reopening that starts May 8th, so a week from tomorrow. The first phase is actually pretty restrictive. The stay-at-home order remains in place. The exception for shopping is broadened, so you can shop not just for groceries, but for other items. So you can potentially go to retail stores, and some retailers can open as long as they comply with both social distancing and cleaning protocols. So some retail stores, things like furniture stores or other things that would not have been eligible to open before, may be able to open. There's still limits on gatherings, no more than 10 people. Some state parks are reopening, although gathering limits are in place. And masks and face coverings are recommended in public, but not required. And we'll be talking about masks as we go through today, because that's one of the things a lot of people are considering. There are some jurisdictions, New York City and the state of Delaware come to mind, where masks are actually required out when you're out in public. North Carolina is one that's recommended it. And then really the state's going to see what happens after that first phase one. They're saying it's probably at least 2 to 3 weeks before we go to a phase two, which would be a broader reopening with certain bars and restaurants opening with some social distancing requirements. So that's an overview of North Carolina. Greg, can you tell us a little bit what's happening in South Carolina?
Certainly. Thank you, Mark. I was actually on a webinar yesterday with the governor, the Department of Commerce, the chair, and our two senators, Senator Graham and Scott. And they all were unified in their commitment to opening South Carolina in a safe manner, but in a manner that takes into consideration the need for people to have their businesses open and earn a living. And so what Governor McMaster has done is he has done a phased opening. The most recent edict from the governor, and by the way, if you look at the PowerPoint that's on your screen, there's a site there to the governor's executive orders. They're very easy to access. If you don't locate this site, you can easily do it with a Google search. But the last one, Governor McMaster issued, is Order 28. And what it says is it expands the number of businesses that are allowed to operate to include furniture, home furnishing stores, clothing, shoe, clothing accessory, jewelry, luggage, leather goods, department stores, sporting goods stores, books, craft, music stores, flea markets, flowers. So things are getting pretty serious here in South Carolina as far as getting back to track with business. And one thing that South Carolina has done that is very helpful is they want to be very user-friendly to the businesses, because as you might imagine, there are probably a number of people on this call who still, after they get a list like that, are not sure if they can stay open. So the governor has delegated to the Department of Commerce the ability to be able to review whether a business can stay open or not. And you can go to the Department of Commerce website, which is there on your screen, sccommerce.com, and you can ask for a clarification of business designation form. Further, on that website, they actually have a list of all of the clarification of business forms that they've evaluated. It's fascinating. I checked it this morning and yesterday. Yesterday they had evaluated 5,800 forms. Today it's up to 5,928, and they've only rejected about 400 or 500. So I'll just give the people on this phone a little feel for the kinds of businesses that are getting approved. Irma Music Dance Studio, TikTok Jiu-Jitsu, Miller Street Dance Academy, Fishhook Charters, all of those were deemed essential by the Department of Commerce. Rejected was Barbell Club, Dockside Owners Gym, and there's a long list. They appear to be focusing on gyms and hair salons and so forth, but to a large extent, they're granting some requests as they come in. So I will commend that to anyone who is unsure about the status of their business, that you should go to the South Carolina Department of Commerce and see if you might be able to open.
Thanks, Greg. That is interesting. And yeah, some of those may not be all that intuitive. Sarah, can you tell us a little bit about the state of things in Georgia right now?
Sure. And, Georgia has been making national news recently for being one of the first states to really reopen businesses with Governor Kemp's order. And we saw April 24th, the governor allowing many businesses to reopen. Specifically delineated were gyms, fitness centers, bowling alleys, tattoo parlors, barbershops, hair salons, dine-in restaurants, theaters, private social clubs, and then a bunch of healthcare practices that had shut down, that were doing elective procedures and things like that. Those are all able to start operating again. So interestingly, while South Carolina is declining to open those types of businesses, in Georgia, they are specifically allowing those types of businesses to open. Now, in Georgia, they do have and have come out with some detailed guidances for businesses that are in those industries so that they can try and be maintaining safety while opening. And there's also a provision for businesses that are deemed non-critical to open with minimum business operations. So that means different things for different types of businesses, of course, but what it really means in Georgia is that potentially almost any kind of business can be open at this point in time. So we're going to get into a little bit more of the discussion in terms of should you reopen, and that is certainly where we're standing in Georgia right now, with businesses having to determine, well, we have the green light from the state, but is that something that we should be doing? Obviously, it's not mandatory for you to reopen, but is it something you should be doing? And since we are going to be talking about liability concerns in this webinar, I did want to mention that the Georgia order, the executive order, provides some liability protection for businesses that do decide to reopen. Now, how that's going to be interpreted by the courts and the extent of that liability protection is something that's to be determined. But it is worth noting that there is something in that order. Additionally, when we're talking nationally, I know that in the next coronavirus federal bill that Congress is talking about right now, there has been some discussions on the floor, mainly from Mitch McConnell and the Republican Party, to include some liability protections for businesses that decide to reopen. So that has not been agreed upon yet, but it is something that's being floated as a potential term in the next package that's going to come out. So that should be something that businesses are watching as well.
Great. No, I think that's good. And let's turn to that question, because obviously, even though your state may say, yeah, you can reopen your tattoo parlor tomorrow, you may not want to, and you may not want to if you're one of the manufacturing clients that have attended here, or one of those large retail operations that's concerned about it. So what are some of the things, and I know we've listed some different areas. You talked a little bit about liability, and I know we're going to be returning to that. Are there some employee-related concerns, Greg, people need to think about as well?
I think the biggest question I've received from my clients are, if we open up our business and one of our employees gets sick, can they sue us? Or are we going to be in jeopardy? Secondary questions have been, what about our customers? What about people who come to deliver services and supplies to our business? And I'll tell you that it's a state-by-state analysis. I'll tell you what the status is in South Carolina broadly. The good news is for South Carolina businesses is we have a fairly solid workers' compensation preemption doctrine, which says that an employee cannot sue an employer in negligence because it's preempted by workers' compensation law, unless, and the exception is, unless there's a deliberate or specific intent to injure. So an employer would have to do something that rises almost to the level of intentional conduct to be liable in negligence. So everything hopefully will be preempted by workers' comp. Now, there's a question as to whether a COVID-related illness that is caught at work would be covered by workers' comp. And I won't attempt to answer that on this call. It might be part of the analysis next week, but I will say, at least in South Carolina, that analysis is going to be very case-specific. There may be some coverage if the person is a hospital worker or maybe a first responder because it's part of their job, but there are also provisions that say general diseases and communicable diseases and so forth are generally not covered. So I suspect we'll see some case law coming out of it. I will tell the people on the phone in South Carolina that I have seen plaintiffs firms who specialize in workers' comp already begin advertising for cases. So the ads are out there, which means the cases will come.
Absolutely. And just to add on to that a little bit, Greg, I know that workman's comp is really a state-by-state issue. So while South Carolina does have that wonderful preemption protection for some employers, that's not the case in every state. And I know we've got a broad audience on the call today, so I want to make sure that everyone realizes that the workman's comp insurance may not cover you in the event that an employee alleges a negligence claim against you. There are frequently gross negligence exceptions in some states for workman's comp, and an employee could easily, with a COVID-related issue, allege some sort of gross negligence on the part of the employer, specifically related to failure to maintain workplace cleanliness or failure to provide appropriate PPE. Other potential liability theories could be, it just totally depends on the facts of the situation, really. But there is a lot of ground there that's ripe for lawsuits, and how it's going to shake out in the courts is still to be determined. So I don't want anyone to get the misbelief that you will be completely immunized from liability by your insurance.
I think that's a great, that's a great point. And I think one of the things we're focusing on in this webinar is steps you may take to eliminate, to reduce your risk of liability. Nothing is going to prevent you from being sued by someone that decides they want to sue you. But how do you, try to win that? I think that's what we're gonna turn to. Before we dig into some of those operational concerns, I know we've also mentioned brand and reputation concerns. And Greg, I was wondering if you wanted to just touch on that, and then we can get into some of those, more specific issues.
And that analysis really is less legal than it is business. But I've spoken to many of my clients who are concerned about being the first back to the market. Will there be social shaming? Will customers criticize them for coming back too quickly? In particular, I note that we have monitored a few neighborhood websites where people in the community mention businesses and how they treat them, and we have noticed that individuals in the community are hyper-focused on how those businesses are treating their employees. Do the businesses have masks? Do the businesses have gloves on their employees? Are they treating their employees well? And then, of course, also, are they taking steps to prevent the general consumer from being injured too? So if you open, when you open, be very careful in appearances, how you're treating your employees, what steps you're taking to protect the general public, because nothing could be worse than harming your brand. If your brand is harmed, then it takes a while to recover.
And, I think a lot of that differs by the local jurisdiction that you're in, right? There's some places in the country that are very ready for businesses to get back to work. And there's other locations where, I'm located in Atlanta right now, for instance, within the city limits. And there was a lot of outrage following Governor Kemp's order. And there's some people that are saying, I'm going to boycott that business if they open too soon. So you want to make sure that you're really taking the temperature of your community. And that might be more important if you're a small business operating in that community than if you're a larger national retailer and you can sort of ride the wave. But make sure that you're taking that temperature and keeping those brand and reputation concerns at the forefront.
I think that's a great point. I wanted to touch on the fact that, we're going to talk about some recommendations to avoid that liability, that may be coming. I do think it's interesting to think about where the risk lies, and it really does vary a little bit based on what your business is. We've got a mix of folks on this call. I think if you're consumer facing, you certainly have some heightened risk from consumers making claims that they got sick, that they visited your store and got sick, or got a product delivered from your restaurant and got sick. So that's an issue. And then there's an issue that runs across all types of companies, which are what happens if employees get sick. And are they going to claim that they got sick because you didn't take the proper precautions? Maybe even that their family members got sick and their grandparent died because they got sick working for you. I think for industrial manufacturing, and we'll talk about some tips for what they're doing, I think the main questions do revolve around protection of employees. And I think office-based companies also have that employee issue, but also if you've got clients getting sick, or you've got people going out and doing servicing in people's homes, for example, that's another way that you need to worry about that exposure.
Mark, I'll just give you one thought on with regard to manufacturing clients. I've talked to several who have employees, over 100 employees, some over 1,000, and they're concerned about two things primarily. One is if the virus runs through their workforce, it could decimate the workforce. So for businesses who are filling orders, who are busy, who are blessed enough to be able to have demand for their product, they are hyper-focused on preventing the virus from impinging on their workforce and causing people to get sick, because if they lose their labor, they're in real trouble. So that's been the first issue, and we'll talk about how to fix that. But then the second issue has been, what about employees who will not come back to work, who refuse to come back to work, who are concerned about coming back to work? And I can just give you a thumbnail. I hope we discuss more about that on another webinar. But in general, the various federal acts that have come down, they don't really protect a person who is fearful of going back to their job. Now, somebody might have a disability, somebody might need an accommodation, but in general, if you're just scared of the virus and do not want to return to work, that's not an excuse. Senator Graham and the chair of the Department of Commerce and our governor were very clear on the webinar yesterday, and they've been very clear in the press that if someone simply just does not want to come back to work, then their unemployment benefits may be in jeopardy.
No, thanks. I think that's a good point. And obviously the decision whether to open or not is a multifaceted decision. It isn't all driven by the liability concerns we're focusing on here. We've put together this slide just to remind you of some of the other things. There are obviously good reasons to open around your business, around bringing people back to work that may be unemployed, around getting the inventory that you may need built if you're one of those companies. But there are limitations, and some of those are infrastructure limitations around the data that's available. But there may be limitations around testing. If you're going to try to do testing of folks, you may have concerns about not having the equipment that you need, or maybe the materials from your suppliers. So it really does require a thoughtful consideration of a lot of different factors, and liability from reopening is just one of those. Sarah, anything in particular you want to touch on in terms of some of the benefits or
I would also just add that in that calculus, that in that math that you're doing, when you're trying to decide whether or not to reopen, there's so many variables that have to be considered, and it really depends on the type of business that you have and the impact that closing or partially closing has had on you and your business. But keep in mind, especially if you are a very large national company of some sort, that you could be facing some sort of liability for not reopening. So if there are states where you are permitted to open and you are overly restrictive, are you going to have suits from employees down the line that have been furloughed that aren't being paid because you've stayed closed too long? If you're a public company, are you going to have shareholder suits because you aren't making enough revenue? So make sure that you're thinking about not just the benefits to reopening, but also risk to not reopening, which is the same side, different side of the same coin.
I think that's a great point, and one that we need to stay focused on. Let me let me actually go back for a second because I wanted to also touch on, some of the risks, and I think we've covered many of these, but and we've talked about employee sickness, and the problems not only incapacitating your own business, but on broader impact on our health system. So that there's definitely some challenges in the decision making as well. Greg, anything you want to add in terms of some of those risk points?
Yes. I would just add, I think I'd like to address a question that may be on most people's minds. Sarah and I, all of us do litigation, and some people may be asking, how big of a risk is this? How in the world is someone going to figure out who caused someone to become ill? And I will affirm that that is going to be difficult. If there are lawsuits arising out of this pandemic, it will be difficult to trace. Tracing will be an issue, but the CDC does have rules and regulations about how to trace the origin of the illness. And although they may not be perfect, there are ways people are trying to do it. So I think that would give the basis for a lawsuit. Second thing to keep in mind is if someone gets sick and has relatively mild symptoms and does not die, you're not talking about an exposure that is significant. Not worth a lawsuit, in my opinion, not worth a lawsuit in many people's opinions, unless maybe it's done on a class basis. So what you're really talking about is the real exposure comes with death or severe illness. So just to put all of the litigation concern in perspective, it will be a very difficult case, and only the cases that resulted in deaths and significant illnesses would have the great value driver.
I think that's a great point, Greg, and I do think that's what people wonder about, right? Is this just a theoretical risk? Lawyers are always telling us the worst case scenario, and I think I think that's part of the challenge. But we all know as trial lawyers, what plaintiffs lawyers like to do is find the right case where you have that death or the right target company, a big company. And I know some litigation's already been filed. So we are seeing it. It's not a theoretical list. And a lot of plaintiffs lawyers want to see how those first cases go as the test cases. And then if they're successful, particularly if they get past what's called summary judgment, right, which is where, can you get the case dismissed before trial? If they survive past that, they often settle, but that's also a green light to other plaintiffs to say, hey, that case can get past summary judgment and get to trial. It's going to have real settlement value, and I'm going to take it on. And I think what we're going to focus on for the rest of this webinar are there practical things you can do to maybe make it less likely that your case gets past summary judgment, where you can actually demonstrate that you've thought about things and what you've done ahead of time. That's really what we're gearing towards. This may be a good time. I know, Sarah, you're tracking some of the litigation that's out there. You want to share, what we're seeing here at the early stages?
Yeah, I mean, we've seen all sorts of different types of lawsuits filed related to coronavirus so far. There's been some class actions that have come up. And I don't know how familiar everyone on the call is, but generally with class actions, it's involving some sort of economic injury that can be generalized across an entire class of people. So if you have a personal injury case where someone's alleging that they've gotten the virus or become sick in some way, that's generally not going to be eligible for a class action per se. That would go potentially, if there were many, many, many cases, it could go into a multi-district litigation where there's individual cases all consolidated for pretrial purposes. But those can be a real headache for companies and massively expensive and hard to resolve. So, we've seen class actions happen so far. We have seen one-off employer actions. For instance, Walmart was sued by an employee that got coronavirus, essentially alleging that, he was not sufficiently protected by his employer. And I think that, to Greg's point, while the liability risk is not astronomical, it is still there. And keep in mind that this is civil litigation. So in my mind, unless you see a federal liability provision that comes into one of these packages that really protects on a large scale companies, it's still a pretty good risk that you're going to get some cases. And the bigger the company, the bigger the risk, for sure. And with civil liability, you just have to have preponderance of the evidence standard, which is essentially more likely than not. So while it may seem like it's difficult to prove that your employee caught COVID, while they were at work, I can definitely see a plaintiff's attorney saying, well, my client says he only went to work and he went home and he didn't go anywhere else. And now he has it, and so you should be liable. And you didn't meet your own, policies or procedures, or you failed to provide him with PPE, which CDC said was in the guidelines that you should have done for the type of business and industry that you're in. And it's real easy for them to make hay out of things like that. So just try and limit those issues on the front end, and that will enable you to avoid and mitigate the risk on the back end.
Yeah. I think those are great. Those are great tips. I think people are, listening are obviously looking for actionable items. What can I take away? There are a lot of checklists floating around. If you Google, COVID checklist or return to work checklist, you'll see a lot of them there. But I do want to provide, my version of a checklist. And again, I think these are not necessarily all things you have to do, because it is going to be individualized to your business. But these are some things I've seen some other retail clients and people in the industry doing that I think make a lot of sense. So I thought I would run through some of those with you to give you an idea of, make sure these are at least discussed. You may decide for your business, some of these don't make sense, but I think this is a good list of things to consider. And the first is having health and safety protocols. I think the protocol can be specific, but some kind of protocol to say, how are we going to deal with this situation? What are we going to do for cleaning? What are we going to do for distancing? What are we going to do to manage it? And doing that thoughtfully and having it written out is a critical step, because I think the lawsuits that are going to be brought saying you failed in your duty are going to say you had a duty to understand that your employees are at risk and you ignored it. And if you don't have anything written and you don't have any guidelines, that makes it an easy lift for plaintiffs' lawyers to say, look, they didn't even write, they never did anything. Everyone had these checklists and protocols, they never did one. I think it's much harder to say, well, you had a protocol, but I think you made the wrong decision, right? I mean, that gets into a judgment about what's appropriate and what's individualized, and plaintiff lawyers are much less excited about having a long fight over whether your protocol was right or you should have done what competitor X was done. But if there's nothing at all there, you become an easy target. I think part of that protocol and part of what you should be doing is thinking about disinfecting. And again, we've got an entire webinar that's going to be focused on environmental stuff in the workplace with a consultant that can talk to you about cleaning and chemicals and schedule. So I'm not going to give you the details, but I think you need to think about that at least for high touch surfaces. There may be some areas where only one person ever uses it. You don't need to worry about it that much. But if you've got break rooms, conference room tables, door handles, shared computer tablets, those kind of things, I think you're going to want some protocol for disinfecting those, because that's where we're seeing transmission. So I think, again, think of your industry. If it's a concern, listen to Brad DeVore's webinar next week. But I think that's important to have some kind of protocol. I think the availability of hand sanitizers to employees and any guests that are arriving is great. Reminder signs about hand washing are a good idea and fairly cheap. Several companies were doing that at the beginning of COVID. So they may still be up in the workplace when you return, but I think those protocols are good. Again, I think focusing on high touch items and the ones I mentioned are important. If you're doing credit cards, that's another area of exposure. Temperature screening of employees, I don't think is appropriate for everybody, but I think it's worth thinking about. And I know, Sarah, you've given some good advice to folks thinking about temperature screening. You want to jump in on that one?
Yeah, I mean, with temperature screening, things that you need to be aware of are HIPAA violations. So you don't want to get into a situation where you are violating HIPAA and you're opening yourself up to some sort of action there. So something that I recommend to my clients and have been doing recently especially is to consider using a third-party consultant to come in to provide, if you are going to do temperature screening or other sort of health screenings, have a third-party health consultant come in. You can hire, a low-level healthcare worker that can come in and actually take those temperatures, and they can be the ones that control the health data and keep that risk separated from your business, so that there isn't any question as to whether or not you mishandled any employee health information.
Yeah, I think that's great advice. Some of the other things to think about, everyone's talking about social distancing, and I think trying to implement social distancing makes sense. I do think you need to think about, again, it's going to be company specific, but how do you actually put that into place in your workspace? And where you can't social distance, are there other things you can do in terms of barriers or other protection? We'll talk more about PPE in a minute. I think a no touching policy for prohibiting handshakes, hugs, and close contact makes a lot of sense, right? That's not the kind of thing that you probably want to do in a COVID environment, and I think documenting that makes sense. The other thing, yeah, Greg, go ahead, jump in.
I would also note that in the governor's order in South Carolina, and I think this is very easy to check on the website, but you cannot allow customers to simultaneously occupy a premises. You can't have more than 5 people within 1,000 square feet of retail space, or more than 20% of the occupancy limit is determined by the fire marshal, and you have to follow social distancing practices, which is 6 feet, can't let people congregate within 6 feet, and then you have to do sanitation via the CDC. So at the state level, there are a few things, but we spoke to the chair of the Department of Commerce yesterday, and what he said is that in South Carolina, the Department of Commerce is going to try to take those general recommendations from the CDC and other agencies, and they're going to try to conform them to various businesses. So everybody on the call should keep a lookout in South Carolina. What we expect is we'll get some more guidance from the Department of Commerce and DHEC about your particular business and how these requirements may apply.
I think that's a great tip, and I do think some limitation on number of guests or customers makes a lot of sense. And we've gotten a lot of questions about, well, how do I calculate it? I put some sample calculations we did with one retail client, but you're right. There are some guidance from the CDC. There's a lot of individual state guidance. There are a lot of questions about, is it different for a grocery store from a furniture store, from a clothing store? What if you've got a food component? How do you figure it out? Things like one-way aisle traffic are, maybe appropriate in your particular location. So the idea is making sure you have space. I know I go to a bike shop that is 3 customers. It's a small bike shop, 3 customers at a time, and they keep the door locked, and you have to wait. And when they release one customer, another one comes in. And I think we're going to see that. But I think it's important, and there are a lot of resources out there. So I think it's important to have some restriction and think about it. Obviously, if you're in South Carolina, you can get specific guidance. That's great. If you're in another state, North Carolina hasn't really done a square footage guidance. Maybe they will before we get to, to that reopening level. You may need to look at what other states are doing or come up with something that makes sense for your industry, because consumers do spend time in different retail establishments in different ways. But again, the goal is to make sure they have plenty of space. Greg?
And I would just ask, and you guys can echo this, as a person who has to defend businesses from time to time, what I want my clients to do is do whatever is kind of the standard of care. The problem is, if you look around in your industry, the standard of care will be changing over the next several months. I would prefer, if there was a lawsuit, for my clients to be on the forefront of that. I don't want them lagging behind the standard of care. So I think would caution everyone to see what other people in your industry are doing. Do not fall behind. Stay abreast and constantly update and monitor.
I think that's great advice. And I bring up things like grocery stores and bike shops because, many places have some essential retail establishments open now. And so I do think we can look to some extent for best practices on, what a grocery store does with aisle traffic or spacing people, waiting. They've had to figure that out because they've stayed open. And I think if you're just now reopening, look for that analog in the essential business, because at least that's some sense of how have they done it, what changes have they made, can we make parallel ones? But I'm with you. I'd err on the side of less people, right? I don't know how many customers you're going to have. You don't want to be the first one to say, 100 people can fit in. It's not a problem. That just seems to invite challenges. I think being conservative and then adjusting over time, Greg, is great advice.
Yeah, I'd also just add quickly that if you cannot find any specific guidance for your particular business on a very specific issue, you have a couple of options. One, I would encourage you to reach out to an attorney to get an opinion from them about what you could do to limit your risk. 2, I would also encourage you to reach out to your local government or your state government whoever is probably the most likely to be able to answer that question, and it sort of depends on what the question is. But, you know, in Georgia, if it was an employment question, you could reach out to the Georgia Department of Labor, for instance, and try and get some communication in writing from them that gives you some sort of guidance that you can stick in your CYA folder so that if something comes up down the road, you have something that you can say, I had this, so this is why we made our decision.
Right. I think that's good. And again, manufacturing clients have faced slightly different challenges, right? Because they don't have the consumer issue in terms of how many people are in the store. But a lot of those, and again, you can cue off to some extent what people have already done that are essential businesses. Look at shift changes. Can you have more shifts with fewer people on each shift? Do you need to close or restrict access to break rooms? And where you have people that have to work together because they're all on the same piece of equipment, do you want to provide masks or other PPE because you can't do the social distancing? I think those are the things to look at. Again, it's going to be pretty plant specific. Where can you make changes to try to minimize the risk? And I think that's what's important to think about. I wanted to kind of gather. We've given some specific stuff, but in terms of people thinking about that best practice, what are some of those? Sarah, let you kick it off here.
Yeah, so I like to think of this in kind of three main buckets. And the first one is to really sit down and plan. So that might be where most of us are at this point. Either you've been operating at a reduced level or you've been closed or some hybrid of those. So you want to sit down at this point and really plan what you are going to do. How are you going to get your workplaces back up and running in a safe manner? With your employees, you're going to want to communicate with them. In this instance, I would encourage over communication. You want to be completely transparent with them about why you are doing certain things and why you are not doing other things. If you think that you're exempt under a certain law and you're not going to provide certain protections, I would encourage you to tell your employees why you think that is the case so that they are informed. People, a lot of times, litigation can be headed off just by communicating with people on the front end. And make sure while you're doing all of these things that you document. The more documentation you can have, the better. And I know that a lot of times lawyers will say, well, I don't want to see that in writing, let's keep that to a phone call, those types of things, because we don't want to create bad evidence. But in this case, I want you to affirmatively create yourself some good evidence. If you get sued, I want to be able to put in front of the jury your cleaning protocol and some emails between your team that decided what those cleaning protocols should be that shows your thoughtfulness in putting together those parameters and why it's specific to your business and why you chose to do what you chose to do. And I think that that's going to help you if you end up getting into a liability situation. And then just a final note that I wanted to talk about for waivers, because we get a lot of questions about whether or not we can just have people execute waivers so that they can limit their liability. For employees, you are not going to be able to have them execute waivers. Generally, employers trying to get their employees to sign waivers of liability have just been held to be unenforceable due to public policy reasons. So that's not going to fly. However, if you are a business that is consumer facing, like a hair salon or a nail salon or something along those lines, I have been seeing businesses use waivers in those situations where really the mitigation efforts that you can take are limited, right? You're going to have to touch that person in order to do their hair. So you can consider waivers in those types of situations, and that may be appropriate there. Another situation where they might be appropriate is if you are running a nonprofit and you work with volunteers frequently, you might want to consider having volunteers execute waivers if they are working on your premises or something along those lines. Now, whether or not that's going to be enforceable for a volunteer will depend on your state law, but it may be something that you want to take up with an attorney and just consider whether or not that is appropriate for your business.
Great. Thanks, Sarah. Greg, anything you want to add in terms of these practices to think about?
I just would, for those businesses who've never been in litigation before, try to envision the story you would want to tell. If someone asked you, what did you do? What did you do? You knew there were risks. What did you do to protect the public? What did you do to protect your employees? Think about the story you would want to tell. And I think the story you would want to tell is, I educated myself, I got good advice, we did everything we could, and that'll make all the difference.
I think that's great. That's great advice, and I'd echo that. And I think the documentation point is so critical because, you know, these lawsuits, people don't realize, you know, they get filed a year later and then get tried 2 years after that. So you're not going to remember exactly what you were thinking about and all your considerations. It's really important to have that documentation. That's what a jury may eventually see. That's what your lawyers are going to look at. That's what the court's going to look at. So, you know, I think documenting that and having stuff to document the thought process is really we did want to leave some time for questions. I see some of you have already put questions in the question box. We did get a number of questions ahead of time as well. Thank you for those. I don't know that we'll be able to answer all of them, and some are kind of specific. We may try to reach out individually, but we will take on questions in just a moment. I did want to remind folks of the resources we do have at the webpage, Womble Bond Dickinson, you know, the COVID-19 Resource Hub. You know, will be the place to start. You can see different video presentations, webinars, articles, alerts, other content there, as well as links to that state closure map that I talked about. If you want, you can subscribe to our alerts as well as our weekly digest. If you don't want to get something every day, you can get a once a week alert that summarizes what we've been doing. I know a lot of your mailboxes are full. We're really trying to focus on you know, useful content that's a little different than a standard news feed and really tries to highlight the legal issues for you. If you're a video person, we're uploading a number of things to a YouTube playlist for COVID-19, so you can sit and watch that if you've got time at home and want to watch videos. So we're trying to make it available in a number of different areas. Most of you are already familiar with Womble. As you know, we've got more than 1,100 lawyers, about half in the US, another half in the UK, and you know, and you can see the footprint there. We've got a lot of different sectors and representation, and we are happy to help in a variety of areas, not just COVID-19. So let's go ahead and turn to questions. Let me start with some that we got in advance. One of the questions that came in said, and you touched on this a little bit already, Greg, but I think it's worth some more discussion. What if someone, and this is from a general manager at Telemedia Broadcasting, and thanks for submitting it. What if someone does not want to come to work and wants to remain at home and say, look, I'm happy at home, I want to stay at home? What are the things to consider in terms of allowing that and allowing it for some employees, not others? What should be the thought process there, Greg?
I've had similar questions from employers, and kind of to expand the question a little bit, some of them have said, hey, can we, to reduce our own risk or to reduce the risk of the workforce, can we maybe send home people who are elderly or who we know might have sicknesses? And I think anytime you treat employees differently, that you're subject to potential discrimination claims. So you can't assume that because the person is old, that they might be maybe more susceptible. You would not want to treat them differently. Similarly, for someone with an illness, like diabetes, for example, you'd want to take great care not to affirmatively, as the employer, treat them differently. If some of those types of people have concerns and they may be covered, for example, by the Americans with Disabilities Act, they have a disability, and a disability is very broad these days. It could be some type of anxiety disorder. It could be something else that prevents them from driving or coming into work. I have seen more excuses for not wanting to go back to the workplace in the past week than I've ever seen before, and you have to tread carefully. If they're willing to have a doctor back that up and sign a certification and a statement saying that they need to stay at home, you need to be careful about it. But the general rule, as I mentioned earlier, is that there's not a federal law that protects someone who does not want to come back to work, or who is fearful of coming back to work.
Great, thank you. No, I think that's helpful. And again, we are gonna have a whole webinar on employment issues too. So if this is a hot button issue for you, you can tune into that as well. Sarah, we got a question from someone at Cambridge Telephone asking that they've taken specific precautions to keep installation teams out of customer homes. What obligations do they have if they want them back in people's homes to complete, you know, some kind of telecommunication order? or complete prior installs. Any thoughts on that?
Yeah, so this goes back to your reopening considerations that we went through earlier, but what you all need to do is you need to get your documentation process in order. So make sure that you have a plan. You know, you have a specific concern here, right? You have installations that have to happen in people's homes. So that is a really specific set of circumstances. There's guidance in the industry from several different sources. So I think you should look at that and you should incorporate it into a written document that says how you're going to address that. You know, maybe I'm just throwing some things out here, but maybe it includes that you're going to provide some sort of face mask to the people that are going into homes, or you're going to take temperatures of people that are going into homes because those are higher risk environments for those employees. So I think really the key is to just documenting what your policy is going to be and then applying it uniformly across the board. So yes, you can get back to work, and it sounds like that's part of your key, you know, core business. So you're going to have to get back into the homes at some point. The question is just going to be whether you can do that safely and whether you can mitigate the risk on the front end. So there's a lot of things to consider, but make sure you're documenting what you're going to do and then applying that uniformly.
That's great. Someone from Trinity Lutheran Church was wondering about nonprofits and churches in particular. And it's true, what we've been talking about, the examples we've given are manufacturers, retailers. What are your thoughts, Sarah, for nonprofits, churches, other folks that would not fit into the, you know, into that manufacturer or consumer focused business?
Yeah, there are liability concerns that are more or less the same for churches and nonprofits. I mean, you know, you've still got the same issues with employees. So if you're an employee of a nonprofit or you're an employee of a church, you still have a duty to, you know, provide safe working conditions for those employees. So take a look at the OSHA guidelines. Make sure that your employment places are up to the guidance levels that OSHA wants you to be working at. And then you need to also make sure in those circumstances, you may have a lot more third-party type people coming onto your premises, right? If you're a church, you're going to have eventually congregation coming in. And if you're a nonprofit, presumably you're going to have some volunteers that are coming in. So you need to be aware of what the liability risks are associated with those types of people as well, and make sure that you're taking the appropriate steps to address that. But yes, the liability concerns that we've addressed today apply to you too.
Mark, may I follow up with one issue?
Of course.
Sarah, speaking about nonprofits, reminded me of something that employers in South Carolina should watch out for. I have a client who is getting ready to start back up, and they have a fairly large workforce, and they're very kind-hearted. And what they would like to do is they would like to spread the pain of the reduced demand over the workforce. That is by maybe reducing shifts down to 30 hours from 40 hours, or maybe reducing pay and so forth. But you need to be very careful whenever you can consider how to bring your workforce back with regard to reducing hours or making it part-time or part pay or reducing pay. The federal government extra benefit for unemployment is considerable, $600 a week. It goes through July 31st. Lindsey Graham says it's not going to be extended. I think there'll probably be a battle about it, but it's a considerable benefit. So, and if you take, in South Carolina at least, if you take your employees back and you cut them to 32, 33, 34 hours, they're still considered full-time, so they wouldn't be eligible for benefits. You can get benefits if your pay is reduced, but in South Carolina, the threshold is really low. So if you make more working part-time or on a reduced hour basis than you're getting for your benefit, then you might not qualify anymore. So sometimes, even though the employer's heart might want to spread the risk or spread the pain over lots of people and all share in the burden, it might actually be best to have some people remain furloughed for periods of time rather than take that stance.
Great. Sarah, we got questions both from Limitless Mobile and Rack Room Shoes about advice concerning masks and temperature symptom checks for folks. You know, are those required for everybody? You know, how do they do it? We talked a little bit about temperature testing, but let's try to address their questions about, does everybody have to wear masks? How is this working out?
Yeah, I mean, it's the most useless attorney answer ever, which is it depends, right? And look at your state guidance. But it does depend. You know, in Michigan, they are requiring everyone to wear face masks. You know, I think that just is cloth masks, and I don't think that I've seen anything requiring across the board mask coverage by any employer. However, there are guidances in place right now regarding who should potentially be wearing masks. And I would say if a CDC guidance or an OSHA guidance or your state guidelines or local guidelines suggest that you provide masks or take temperature checks for certain types of employees, I would, like we were saying before, consider that to be a across the board sort of standard of care, because that's what attorneys are going to look at later and say, well, that was the recommendation that you should have been working at. So I would consider that a soft requirement, although it's not required technically. It will limit your liability if you comply with all the guidelines.
Yes, literally, if I had a retail store, I would, with very close attention, walk through Target and Walmart and maybe Publix, and I would see what those big box retailers are doing, and I would try to mimic it. I would not want to do anything less.
That makes a lot of sense. Any thoughts while we're talking about temperature? I think Kai Velasquez wrote in asking about having employees take their own temperature or do some kind of self-reporting. Sarah and Greg, any thoughts on that as opposed to hiring some outside temperature taking organization?
Yeah, I mean, I think you just have to be careful about what you're doing with health information, right? So, you know, maybe if you don't want to hire an outside person, use, you know, your HR person, who would usually be the one that would be dealing with like FMLA claims and things like that, to be the one that gets in the temperature information. I think that, yeah, you can ask your employees to take their own temperature and you can provide the thermometer. I don't think there's anything wrong with that or preventing you from doing that. It's just going to be a matter of what do you do with that information and making sure that you document it and that you're implementing that procedure in a fair way, right? You don't want to be later accused that you have been discriminatorily asking some people to take their temperatures and not others. So just make sure whatever you're doing applies to everyone.
I think that's good advice.
Similarly, if the business down the road is taking employees' temperatures as they walk through the door and another one is relying on their employees to take their own temperatures, it might be a different set of plaintiff's attorney would note in future litigation.
And I see Lisa had a question about bylaws requiring meetings of membership. We do have a piece on our website talking about virtual meetings and ways to do it and whether it can comply with corporate requirements. I still think a lot of companies are holding board meetings in a virtual environment like this as opposed to getting together. I think that is likely to continue on for a while. I know we have we've gotten other questions in, and again, if we haven't answered yours, we can try to answer those individually. You're also welcome to contact me or Sarah or Greg, you know, and follow up with those as well. We will be making slides available to everybody, and this webinar has been recorded, and it will be available on our website sometime by the middle of next week. So if you think other folks in your business would like to watch it, you can send them those links, and we encourage you to watch those. And again, the slides will also be available for download. And Sarah, Greg, and I will be available. Any final remarks, Sarah and Greg, as we sign off? I know we've got a lot of busy people out there, and we've hit the end of our hour. Sarah, I'll start with you. Or Greg, go ahead.
Our hearts are with anybody who has a business, and we want the best for you. We want you to open. We want you to protect your employees and your customers. We'd be glad to help you.
Absolutely, and I would just echo what Greg said, and if anyone wants to have a one-off conversation, we are available. I think, it's easy to find my email if you want to reach out to me. I've also got a lot of experience dealing with PPE, so face masks and hospital gowns and things along those lines. So if you have questions about specific requirements related to those, I'm happy to walk you through some more, some of those regulations and things relating to those products. If that would be helpful to you.
Great, thank you. All right. Well, I share those thoughts with everybody. Thank you so much for joining us here on the first of the Back to Work series of webinars from Womble Bond Dickinson. We're excited you could spend part of your Friday with us. Look forward to seeing you at future webinars. Wish you all the best business success, and we're here to help in any way we can. Thanks, and have a great rest of the day.